up Facebook. Hi, Facebook. All right, so we are all here. Oh, I got people from Houston, Texas, Athens, Georgia, and Richmond, California. Hey guys. Thank you so much for joining. Again, hi, Facebook. I know that I have a lot of people who joined today from blackwallet.org and possibly Black Women Are Poppin'. Welcome, welcome, welcome to the fun. All right, happy Thursday, everybody. Happy Thursday. We have made it to almost the end of the week. Thank you for joining. Like I said just a moment ago, I'm Natalie Pierre-Louis. I am the owner and operator of NPL Consulting LLC, and this is NPL Legal Dish. This is my weekly live broadcast where I teach you business concepts that you need to know if you are, an aspiring entrepreneur, things that you need to know. I help to teach those concepts using celebrity stories and interesting stories in the news. Just a little bit about myself. Again, I'm the owner and operator of NPL Consulting LLC, a business formation firm. What that means is I help get your business paperwork started. So if you need help with registering your business in your state, if you need help with protecting your intellectual property, like through trademarks, patents, or copyrights, if you need contracts, if you need to know how to get an EIN number, if there are infrastructure issues that you need handled, I help you do that. You might be wondering, why am I qualified to help you do this? I am so happy that you asked that question. I have been a licensed attorney for over a decade. I have started multiple businesses for myself and others. I've had many careers in the realms of law, education, entrepreneurship, hospitality, and administrative support. And most important, I'm very passionate about making business and legal education as accessible to everybody as possible. Not everybody has the time, the money, or the desire to go to business school or to law school, but so many of you guys have these amazing business ideas. And no matter what your business is, there are just basic concepts that you need to know, all right? And that's why I'm here. If you are interested in any of my business formation services, or if you want to just chat and see how I can help you, you can go to the link in my bio, linktree/NPL Consulting Firm, linktree/NPL Consulting Firm, linktree/NPL Consulting Firm. There you're going to be able to book your free 15-minute consultation for first-time clients. You're also going to get some cool freebies. Right now I have the business launch cheat sheet that is for free download. It is a great document. If you have a business idea but you just don't know where to get started, this is going to help you jumpstart that. Okay, so download it. It is completely free at linktree/NPL Consulting Firm, the link in my bio. All right, so now on to the show. Every week, I pull stories from the news and I talk about different celebrities, about different funny businesses. We have a great time on here. If you have a question about any of the stories that I am talking about, sometimes I can go a little fast. Drop your questions in the comments. Or if you have a comment about something, I'm going to ask for engagement. But these stories, I pull them because some of them are funny and they all have, thank you to whoever's coming in, come on in. They all have the purpose of helping you to understand the fundamentals of business, particularly trademarks and contracts, all right? So we are going to get started in just a moment. All right, so the first story that we are talking about today is Cars for Kids, Inc. versus America Can Cars for Kids. How many of you guys have ever heard or seen the billboards for that charity, Cars for Kids? I know that I've seen them a few times. If you have seen billboards or you've ever heard of a charity called Cars for Kids, please give me a C in the comments. I'm sitting on a Swiss ball, like one of those exercise balls, so it's gonna look like I'm wobbling. But if you've ever seen or heard of those charities that do cars for kids, give me a C in the comments. All right, I got one C. All right, now we're gonna move forward, okay? So there's these two companies. There's one called Cars for Kids, and Cars is spelled with a K, Cars for Kids, Inc. They're located in Lakewood, Texas, right? So they started their charity, and they even had a phone number. It was, thank you, hello to whoever came in on Facebook. It was 1-877 Cars with a K for kids. So this was this company in Lakewood, Texas. And then you had this other charity, America Can Cars for Kids, where the cars is spelled with a C. They pretty much did the same thing. They help families obtain vehicles, families with kids. They both sued each other for using the phrase cars with kids. Ooh, excuse me. My throat is a little dry. They both sued each other for using the phrase cars with kids. Hello, Miss Whitney. And you would think that because they're charities, they wouldn't care that one or the other is using the phrase. However, Cars for Kids is a very lucrative charity, and it's a name that you're going to want to keep. Now, they haven't met yet in court. They both just sued each other. So we're going to get updated in a couple of months. Hello to all the people that are coming in. We're going to get updated in a couple of months as to possibly who owns the rights to the phrase Cars for Kids. All right. And the reason why I picked this story is to help you guys understand that branding is very, very important when you are going into business. Cars for Kids is even if it's not in your conscious brain, you kind of know, you've heard about it in the back of your head. Now, if you're someone who wants to donate to this charity, but there are 800 different Cars for Kids, how do you know which is the right Cars for Kids that you want to donate to? That's why branding is very important, and that's probably why they're suing each other. All right. Next story. If you have any questions about that, please feel free to drop them in the comments. All right. The next story we are talking about has to do with Rebel Media, which is a very conservative media group. They are suing a Canadian company over hats that said "Make Canada Great Again." So apparently, Rebel Media owns the trademark to Make America Great Again. So we know what their politics are, right? They have filed a series of trademarks in the United States and in Canada for Make America Great Again, and they filed for one in 2015 for Make Canada Great Again. But this store called Hudson Bay is, they've been making Make Canada Great Again hats without the permission of Rebel Media. Now, I don't ascribe to the Rebel Media politics. However, they have branded themselves under this phrase, and they are well within their rights to go after another party who is infringing on their trademark, right? So when you have a company, even if you don't agree with their politics, every company has the right to brand themselves, to let you know this is what you get when you're coming to our company. So Rebel Media is trying to preserve their branding both in the United States and Canada. Whether or not you like their politics or not, legally you can protect it. All right. Oh, next story is a fun one. We have a story about Kanye West versus a Japanese fabric company. If you are or have been a fan of Kanye West, or you know one of his songs, give me a K in the comments for Kanye West. Kanye West. I'm pretty sure everybody should be able to give me a K in the comments because his music is everywhere. I think he's gone off the deep end a little bit lately, but his music is undeniable. So if you have ever heard of a Kanye West song, give me a K in the comments. Gumbo Gris. Okay. Yeah, I thought that was a mistake. All right. Gumbo, is that Gumbo Gris or Gumbo Gris? Let me know how to pronounce that. I love how it's spelled. It's so cute. All right. Most of us have heard of the artist Kanye West. His music is iconic. He has clothing lines. Now, to make a clothing line, usually you need to partner with some type of factory or fabric provider, right? So apparently Kanye had a contract with a company in Japan named Tokisen. And they sued Kanye for breach of contract and for fraud. They said that he signed a $600,000 contract. They said that he had a $600,000 contract with them and he didn't honor it to get fabric. And they also claimed that it was a fraud because he was using his Yeezy company as just a way to avoid legal liability. All right. Now, Kanye's lawyers, basically their argument is it doesn't matter whether Kanye is the sole. So the reason why the company said that Kanye is running this company as a fraud is because he's the only owner, he's the only member. There is nothing wrong with this. When you are setting up a business, if you are the sole owner, you can set up a sole owner LLC. That's what I did for my business. I'm sole member. Just because I'm the only person in my business, that doesn't automatically mean it's a sham. And that's what this company is saying about Kanye West. They're saying that his Yeezy company that manages his clothing line only has him as a member, so that means that it's a fraud. Now, if you're looking at it from a reasonable point of view, someone who is as prolific and as busy as Kanye probably has a bigger team and probably has people who have stake in his stuff. But we all know Kanye is a little bit, whatever. So I wouldn't put it past him to have just set up this company in his name. He just has people working under him. That is well within his right. This Japanese company is saying the fact that this company is only owned by Kanye and nobody else means that he's just using the company to skip out on any personal liability for lawsuits that might come against him. All right. They are also saying that there's no proof that there was any fraud because there was no there's no proof of commingling of funds. When you set up a business that is like an LLC or anything that requires actual paperwork, anything other than a sole proprietorship or a partnership, you need to have separation of your business funds from your personal funds. If you don't do that, it's called commingling of funds. And then if somebody sues your business and they see that you're using your business basically as an ATM, they can say, well, you and the business are one and the same, so no corporate protection. So his lawyers are saying, show us where Kanye was using this company just as a personal ATM. Then the other thing that they're asking to prove is that if you are the only stock owner in a company, if a company has all the stock and then you own all of those stocks, it can be kind of a front for the business. And they're saying, well, show us where Kanye owns stock in this company and he is the sole stock owner. So we're going to see what happens with this case. They're saying that there was no proof that he accepted the contract, and there was also no proof that the company did their part on a contract. Now, if you've ever watched me, you know that I have said that a contract requires offer, acceptance, and consideration, right? So if you write a contract and you say, I'm going to mow your lawn for $50, and I say, okay, but you don't mow my lawn, you haven't fulfilled your part of the contract. His lawyers are saying, even if Kanye signed this contract, which we're not saying that he did, you guys haven't done your part yet. So where is the breach of contract? So now the judge agreed with Kanye's lawyers, and he's giving the Japanese fabric company time to go and revise their complaints to the court so they can show, okay, here's the reasons why we said, hi, Whitney. Here are all the reasons why we think that this whole thing is a sham and it's breach of contract, and Kanye was just using this company as a way to avoid any legal liability. So we're going to get updated with that. Let me take some time to reintroduce myself. I'm Natalie Pierre-Lewis. I'm the owner and operator of NPL Consulting LLC, a business formation firm. This is NPL Legal Dish. This is my weekly live broadcast where I teach business and legal concepts using stories in the news, celebrity stories, funny stories that I find, If you ever have a story that you want me to talk about, please feel free to DM it to me, email it to me, get it to me. However, I would love for you to submit stories. I'm only one person. I can't catch everything. But if you ever find a story in the news that has to do with people, you know, celebrities and their businesses, or trademarking, stories like that, contracts, send them to me. I would love to talk about them. As well, if this is your first time with me, please go to linktr.ee/nplconsultingfirm to see all of the nerdy things that I do. Your girl likes to write ebooks. So go check out the ebooks that I have up there. There are some sneak peeks that are totally free. Go download my business launch cheat sheet, which is going to give you a jump start to get those business ideas started. As well, you're going to be able to get the link to the latest episode of my podcast where I interview different entrepreneurs to ask them about the daily business, you know, tasks that they have to do and how that, you know, applies to their industry. So I do a lot because I love it. But let us get back to our stories. Okay. Oh, if you guys have any questions, drop them in the comments, okay? How many of you guys have heard of the brand Supreme? If you have heard of the brand Supreme, please put an S in the comments. And just to kind of jog your memory, Supreme, it's a red block with white lettering. If you've ever heard of Supreme, if you like Supreme, let me see an S in the comments. All right, V-Trend, hey girl. V-Trend said S. We got one. Falcon Chris said S. All right, I got another S. Okay, we know who Supreme is. So you guys who said S, I think you're new, so you did not hear the story that I did about this a few weeks ago. So Supreme New York, it's based in New York. They've basically only been focused on the United States. And while they have trademarked themselves in the United States, an Italian company basically hijacked the Supreme trademark in China. And they had Chinese trademarks for Supreme. And Supreme sued. They're like, yo, that's our brand. What are you doing? And that story, I had picked it that week because I told the people who were watching that it's very important that you protect your brand all the time. Supreme was so worried about stateside that they didn't even look overseas. And an Italian company was able to get 2 trademarks in China for the Supreme brand. Like, it looked exactly like Supreme. It was nothing different. All right. So here's what happened. Okay. Basically, Supreme in New York went to China and said, look, these people, they stole our trademark. They can't do this. And China agreed, and China has taken away this Italian company's trademarks in China. Like, it got so bad that this company actually had a collaboration with Samsung in China. That's how big they had gotten. And they set up a brick and mortar store. Yeah, they had 2 retail stores in Shanghai. This is a counterfeit Supreme. This is all while Supreme is in the US. They're not knowing any of this is going on. So the thing with Supreme is they don't have any official trademarks in China, but they do have 85 applications pending. Yeah, why? They got them. They did get them, Falcon Chris. They got them. Trademarks are big business. Like, if you watched last week, there's a story. There's a guy in Australia who just got fined almost $500,000 because he was selling fake Uggs. He's one guy, and he has to pay Deckers, the company that owns Uggs, he has to pay them $500,000. Trademarks are not a joke. So, yeah, so this Italian company, it was called Supreme Italia. They've lost their trademarks in China, and, you know, doesn't look too good. Next story. Oh my gosh. So this is kind of, if anybody here is a Patriots hater, get over it. I'm a Patriots fan, and this story has to do with the greatest quarterback of all time, Tom Brady. So Tom Brady has filed a trademark application for the phrase Tom Terrific. I think it is an apropos trademark. I think Tom Brady is terrific. He's a great quarterback. Judge me if you want. Can they get the money they made off of them? Falcon Chris, I don't know what Chinese. Falcon Chris, I don't know what Chinese trademark laws are like. I know that the trademark laws are changing in China, but I don't know what they're going to be able to get from this company in China, because remember, they filed this case in China, even though they had to, because they're a U.S. company. But it's a demonstration of why international trademarks are very important. Why are you're booing my love for Tom Brady? Oh my God, I can't believe there are so many Patriots haters here. It's lonely at the top, y'all. Anyway, Tom Brady has filed a trademark application for the phrase Tom Terrific. The problem is he's pissed off a lot of Mets fans and New Yorkers in general, because Tom Terrific was the nickname of a famous Mets pitcher by the name of Tom Seaver. So there's always been this, like, New England, New York rivalry, whatever. I remember when the Giants beat us twice. I will, admit to that. It hurt, but whatever. There's always been this New York, New England rivalry. And for Tom to take this moniker that is well known, I actually read an article today by a BU professor who is, a Patriots fan. And she was like, well, this wasn't even your original nickname. And Tom Brady has another nickname that he has started, a line of like merchandise for. So why would he file this application for Tom Terrific? But we'll see if he'll get it. Still greatest quarterback of all time. Go Patriots. Hey. All right. Next story has to do with a very, a little brand. You might not have heard of it. It's called Nike. If you've heard of Nike, and I won't blame you if you haven't, give me an N in the comments. If you have heard of Nike, give me an N in the comments. You're a Raiders fan? Okay, everybody is a fan of a team. I'm born and raised in Boston, so I have an excuse. And we win. All right, I got an N for Falcon Chris. All right. Okay, Gumbo. Okay. You got to tell me how to pronounce that. All right. This next story has to do, thank you, V, has to do with a guy named, a basketball player named Kawhi Leonard. He's suing, He's suing Nike. And here's why he's suing Nike. Okay. And I think that Nike's really shady for this. So in 2011, Kawhi Leonard, he partnered with Nike for endorsement deals. And they used a design that he created himself while he was in college. Like, he gave them the right to borrow the design for this merchandise that they were going to make. And it was a design of hands with Kawhi Leonard's initials and the number 2, right? So, they were in negotiations. They were going back and forth. Gumbo Gree. Oh, thank you. So they were going back and forth for years, apparently. He accepted their proposal in June of 2014. He said that they could use the logo, but he said he never gave them the rights to the logo. So he was saying, yeah, I said you could use it. I didn't say you could have it, right? And he said, and he has like emails and text messages to show that. So he was also using this logo on his own merchandise that he was making, and Nike didn't say anything. So he told Nike, yeah, you can use my logo. And then he also had his own merchandise that he was selling with that same logo, and Nike didn't give him a problem. But here's where it gets kind of funky. Nike filed an application with the Copyright Office for that logo that Kawhi Leonard created, okay? And they said that the logo, it was a work for hire. So basically they told the Copyright Office that they hired Kawhi Leonard to make this design for them. That's what they told the Copyright Office. Kawhi Leonard filed a trademark application in 2017 for that logo so that he could officially sell his merchandise. He wanted to start, probably like a clothing line or something like that. Because I want you guys to remember that when you're trademarking something, if for clothing, it has to be for the label. It can't just be a design on the shirt, okay? It has to be like for your line. Anyway, so Kawhi Leonard files his trademark application, and Nike rolls up on him and tells him to stop using the logo and to take back his application. And they said that they own the rights to the logo. Kawhi Leonard told them, you need to drop the copyright because the application is wrong. And he said that, and he has filed a suit saying that he is the only owner of the rights to that logo. So I don't know how to feel about this. Like, why would Nike, you're like $1 billion company, take this man's logo and say it's a work for hire? Like, if there's all this proof that you weren't given the rights to this, why would you do this? Like, and something that's so provable. It's something that he created while he was in college. Hi, Danielle. So if he created it in college, how is it a work for hire? I'm sure he didn't know he was, going to get an endorsement deal with Nike while he was in college, Anyway, so we will wait and see what happens with that story, okay? Okay, this next story, if you guys have like teenagers, if anybody has teenagers, have you heard of Brandy Melville? Apparently it's a brand. I guess my dog's heard of it. If you got teenagers, apparently there is a very popular brand called Brandy Melville. My fearsome beast is protecting my home. Sorry for the barks, guys. And apparently, Brandy Melville, they are a company. Their whole thing is it's one size fits most clothing, and they also sell accessories. They've been around for like 30 years. So has anybody heard of Brandy Melville? I've never heard of it before this story, but apparently they've been in the game for a long time. Yeah. Hi. Nobody knows Brandy Melville? Okay. So they're suing this website called Redbubble. And Redbubble, it's kind of like an Etsy. It's an online marketplace for creatives, right? Brandy Melville, they're 30 years in the game. They find out about this new, this new marketplace in 2018, and they sue them. The marketplace, the Redbubble, they're like, well, we just sell items, that people make. And now Brandy Melville is saying that they want $2 million for every item that Redbubble has sold. Because if you've ever been on Etsy, right, you'll see on Etsy that people are selling like fake Louis and things like that. Basically, what Brandy Melville is saying is they want $2 million for every item that was sold on Redbubble that had their mark on it. That could drive Redbubble out of business, right? And they also want 3 times the damages. Now, remember, Brandy Melville is trademark. When you have an official trademark, you can be entitled to 3 times the damages that you get. So, like if somebody, used your trademark and made $1 million, you can sue for 3, depending on how egregious the infringement was. So they're saying they want $2 million for every item that was sold, and they want 3 times damages. So we will wait and see what happens with that. Oh my goodness, we have such a full room today. Hello, everybody. Let me stop and reintroduce myself. I'm Natalie Pierre-Lewis. I'm the owner and operator of NPL Consulting LLC, a business formation firm. What that means is I help you get your business paperwork together. If you need any help with registering with the state, getting your contracts, getting trademark, go to linktr.ee/nplconsultingfirm and set up a free 15-minute consultation, all right? Also, you are watching NPL Legal Dish. This is my weekly broadcast where I demonstrate business and legal concepts using celebrity and pop culture news. We have a good time here. I'm a nerd, but I like to keep it fun, all right? So that's my commercial. Let's get back to the show. How many of you guys have ever seen the or heard of the company Caterpillar? They do like big machinery. If you have heard of the company Caterpillar or you've seen their machinery, I think they might make boots too. Give me a C in the comments. Their logo, it's like, it says C-A-T, it's a cat, it says cat, and it's yellow. They're always yellow. If you've heard of Caterpillar, if you know what I'm talking about, give me a C in the comments. If you don't know what I'm talking about, give me a, oh, I got a thumbs up. All right, Falcon Chris knows what Caterpillar is. Okay, so here is, okay, I got another, yay, thank you, Gumbo Gree. All right, so this is the case of Cat and Cloud versus Caterpillar. And this is a case of Caterpillar being a very, very petty company, and in my opinion, a case of trademark bullying, which is a thing. Companies with a lot of money sometimes go after little companies because they can tie them up in litigation to like try and corner the market on trademarks. And this, I think, is a really good example of that. So here is the story. Cat and Cloud Company, they are a coffee company. So they sell coffee and they sell like merchandise that says Cat and Cloud, right? And they have a trademark for clothes. Their trademark is a cat dressed in a hat, wearing a t-shirt with a lightning cloud. So I want you to imagine that. A cat with a hat, not the cat in the hat, but a cat wearing a hat, wearing a t-shirt as well, and a lightning cloud. So that is their logo. Caterpillar sued them and sent a cease and desist and filed a lawsuit against them, objecting to the use of the word cat in their logo. Okay, now we all know the cat logo. It's like that, it's black block lettering with that yellow triangle underneath it, right? No, in my opinion, no correlation with this logo from a coffee company. Caterpillar is a company that made $13.5 billion in the first quarter, all right? They do their trademarks are for machines, engines, services, etc. Cat and Cloud is a coffee company. They sell coffee and they sell merch. And their logo is nowhere near Caterpillar's. On top of the fact, Cat didn't try to go after the Dr. Seuss, the Cat in the Hat company. They didn't try to go after the Cat in the Hat for Dr. Seuss, and they also didn't go after Target for their Cat and Jack line. So again, this is why I think this is a case of trademark bullying, because why are you going after this little coffee company that has a logo that is nowhere near yours simply because they use the word cat? That's like all these cases that Monster has of going after any company that tries to use the letter M in their logo, and that's why they keep losing. Yeah, and why I say this is trademark bullying, you're basically bullying them because you have more money, because it costs the coffee company anywhere between $10,000 and $20,000 to try this case. As a small company, you don't have $10,000 and $20,000 to whip around like that. But a company that made $13.5 billion in the first quarter does. And that's why big companies can bully smaller companies using trademarks. So stay woke. All right, guys, if you have any questions about the stories, please drop them in the comments and I will gladly answer them. The next story we have, it's bittersweet, I will say. Hi, long live hell. I can't see the rest of the name. Anyway, so if you were here last week or the week before, I talked about Nipsey Hussle and how the Crips wanted to trademark his phrase, "the marathon continues," for like a whole host of positive things. Like the Crips are trying to turn it around and, you know, make themselves like a respectable organization. They want to help the community. They want to do gang intervention, all this stuff. So they put a trademark application in for the phrase, "the marathon continues." Unfortunately, so has Nipsey Hussle's brother. His name is Samuel Black Sam Askedom, right? He's also seeking control of Nipsey Hussle's estate. I don't know what's going on back there. I haven't really paid attention to the whole family dynamics. The problem is his brother filed the trademark 2 weeks after the Crips did. Now, in the world of trademarks, usually the person who files first gets the trademark, unless there are extenuating circumstances. So, depending on what Nipsey Hussle's brother can prove, like, did Nipsey want him to have the trademark? Was there some type of agreement? The Crips may get the trademark over him. It will depend on the person who hears this case and who puts up a better argument. I don't know anything about Nipsey Hussle's family dynamic. I don't know, his relationship with his brother or his relationship with the Crips. I think he was cool with everybody. So I hope that this can come to an amicable, decision. Maybe they can all put together, because the brother wants to trademark the phrase for pretty much the same thing that the Crips want to. So actually, I want to know what your opinion is as a group. Do you think that the Crips should be able to get the trademark because they did it first? Or do you think that the brother should get control of Nipsey Hussle's trademark? Yeah. So who do you think should get it? Do you think the Crips should get it because they were first in line, which is the usual rule? Or do you think that because this is family, the trademark office should look to that and take that into consideration? They should collaborate to keep it peaceful. Okay, I agree too. I hope that something like that happens. But what if they can't? Who do you think should get it? First come, first serve. Passionate Pro said first come, first serve. Crips did it first, so they should get it. Okay. Crips. Falcon said Crips. Hi, Champagne. Look lush. Hey, friend. Y'all look lush naturals. We grew up together. Black Sam, it's respect. Okay. Long live Hell Von Forever said Black Sam should get it out of respect. Okay. Champagne Jimmy. Oh, we got a full house today. I feel so special. Thank you guys for joining. I know a lot of you came over from blackwallet.org. Thank you so much for following. Yeah, your girl is here for your business formation services. Check out the link in the bio. All right. Okay. All right. So we're finished with okay. Passionate Pro said, or maybe whoever was in business with him, like if he had a business partner. Gumbo Gregory said, I believe if the brother is over his estate, then he should get it. But I don't think Nipsey had a will. I hope he had a will. I feel like he was financially responsible enough to have a will. Gotta go. Great info. All right, Falcon Chris, you'll be able to watch the replay later. It'll be up on YouTube and Facebook as well. Okay. All right, so we're going to move on to the next story. If you want to DM me your comments about the Nipsey Hussle story, the Cribs versus the brother, let me know. Next story we're talking about, how many of you guys have used Badia brand spices? I have used them. I have seen them at, you know, my international markets. The brand name Badia. Badia. Badia brand spices. If you've, I should probably give you a, okay, give me a B in the comments if you heard of Badia. A B. Give me a B. Give me a B. I was watching a Janet Jackson video clip. Okay, Gumbo Grigri loves Badia. All right, so there is a rival, I guess, spice company named Jail Spice, right? And Badia has sued Jail Spice. Look Lush Naturals knows Badia. Badia has sued Jail Spice over the phrase sazon completa, okay? So basically, Jail Spice has something called Spice Supreme Sazon Complete Mix Seasoning. And Badia is like, we own Sazon Completa, that's part of our brand, you can't use it. Jail Spice is saying Sazon Completa is a generic term and it's not entitled to a trademark. So remember, you can't trademark regular words, right? For in your industry. So like if I'm selling apples, I can't trademark the word apple. So if I'm selling, you know, Sazon Completa, if Sazon Completa is just a generic term for a brand of, for a category of spices, I wouldn't be able to trademark that most likely. So Jail Spice is saying Sazon Completa is a generic term. It's not something that can be trademarked. And they're also saying that there is no way that their name, Spice Supreme Sazon Complete Mixed Seasoning, is going to be confused with Badia's, because that's another one of Badia's arguments, that people are going to confuse Jail Spice's stuff for Badia stuff. Now, they haven't met in court over this yet. This is just paperwork that's been filed. So we're gonna wait and see what happens with that case, and I will update you guys. Okay. Okay. Next story. Oh my God. Steak lovers. If you are vegan, close your ears. But how many of y'all like steak? If you like steak, give me a thumbs up in the comments. My steak lovers. This has to do with a steakhouse chain. None of y'all like steak? Well, I love a good steak. All right. And this story has to do with competing steakhouses. So there is a steakhouse chain. Look Lush Natural says it tastes good, but I'm trying not to go there often. You better than me. I eat meat at every given opportunity. All right. So here's the story. There's a southern chain of steakhouses called Oak Steakhouse. Okay. And they have an official trademark for their name. They were smart. They said, this is a thing that we're going to grow. We're protecting our brand. So they trademarked the phrase Oak Steakhouse for steakhouse restaurants. All right. And they started in 2005 in South Carolina. Now, in 2017, a company in Easton opened a restaurant named Easton's Steakhouse. And then Oak Steakhouse found out about this and was like, oh, no, this is causing too much confusion. And here is what they said. This is the proof that we have that there is confusion. Now, remember, trademarks are meant to kind of, protect your goods in the marketplace. So if somebody takes your mark and starts, selling something like what you do, that causes confusion because people are going to them because they think it's you. So Oak Steakhouse is saying there's a lot of confusion going on. Here's what happened. people who were applying for the Easton Steakhouse would come to Oak Steakhouse and vice versa. Also, people who wanted to go to the restaurant would make reservations at Oak Steakhouse, one of the chains, and then go to Easton and find out they have no reservation, and vice versa. So people would interchange them. And also people would try to turn in gift cards from Easton's to the Oak Steakhouse chain. They're not affiliated with each other. They have nothing to do with each other. However, they also said that Easton Steakhouse modeled their Instagram page similarly to Oak Steakhouse, and their exterior appearance is very close to that of Oak Steakhouse. So there is a credible argument here that this company is trying to profit off of the popularity off of this Southern Steakhouse chain, even though they're not affiliated with them. So we'll wait and see what happens. We'll see what Easton's Steakhouse responds with, because I mean, it could literally be a coincidence, but it seems like too much coincidence for it to be just that. So we shall keep an eye on that. All right, we've only got a couple more stories. I want to remind you guys to go to the link in my bio to download the free business launch cheat sheet. All you guys who have amazing business ideas and don't know where to start, it's going to give you a great launching pad. It is completely free, okay? Okay. Have any of you guys ever watched the XFL? They're no longer in business, but they had a good run. It was an alternative football league. I'm vegan-ish. If you have heard of the XFL, give me an X in the comments. Oh, sorry. Oh, shoot. Oh, shoot. I didn't even see Nicole was here. Hey. My thingy didn't go down. Okay. Gumbo Grigri heard of XFL. Okay. There's at least two of us out here. Look Lush said no. Okay. That's cool. XFL, it wasn't that popular, I don't think. I wasn't like a super fan or anything, but I know I watched a few games. Anyway, so XFL was an alternative football league, and there was a guy who played named Rod Smart, and he had a phrase called "He Hate Me" that he would wear on his jersey, and he continued to use this phrase after after the XFL finished. Like, he even had a Twitter account that was called @HeHateMe, and he was tweeting on it as late as October 2018. Okay, now in 2016, the XFL applied for a trademark for this phrase. So basically, Rod Stewart creates these phrases. He's wearing it on his shirt. He's using it till 2018. And in 2016, XFL is like, well, we want to do something with it. And they go and they file an application. The USPTO office says, did you get Rod's permission? Because we know that this is his phrase. See, when you submit an application to the USPTO office, they have an actual attorney who goes over the application and does the research to make sure that you're not infringing on anything else. So someone got this application, did their research, and said, this is somebody else's phrase. So they said, did you get Rod's permission? The XFL responded to them, and they said, well, that phrase doesn't belong to anybody. And the USPTO said, what are you talking about? Does Rod Stewart know what you're doing with this? And the XFL said that Rod Stewart was going to have nothing to do with this project. So I'm pretty sure that this is going to get denied, because they're basically trying to steal this man's phrase. He's been using it for years. And even though he may not have had an official trademark, he owns, like, he has branded himself as this. People know this phrase is associated with him. He used it on jerseys. It was his Twitter handle. So there are certain default rights that you get when you create something, and that's what the USPTO office is saying. They're like, you guys didn't create this. Somebody else created this, and you need to show us that you have this person's permission. All right? How much? Okay, I got like 10 minutes left. I think that's enough time to do this last story. Oh, 2 more stories. Okay, so these are really quick. If you've heard of Jordan Woods, give me a J in the comments. If you pay any attention to pop culture, you know who Jordan Woods is. Kylie Jenner's best friend, or former best friend, I should say. She was on Red Table Talk. If you have heard of Jordan Woods, give me a J in the comments. Okay, I got 1 J. So we can go ahead, all right? So Jordan Woods, she submitted a trademark application in 2018 for a brand that she has called Second Nature, okay? Now, when you submit an application to the USPTO office, when they respond to you, you have about 6 months to respond. I got 2 J's, awesome. Jordan Woods never responded, right? So now her application is dead. What that means is if you don't respond in time when you have submitted an application to the trademark office, they will just cut off your application. You're going to have to start from 0. So if somebody is just being vindictive, they could, and she isn't paying attention, they can go and file a trademark application for that same phrase, Second Nature, because her application, it's dead. It doesn't exist. So yeah, so now she has to file a new application. And this is why you need to keep up on your correspondence when you're filing a trademark application. If you need help with that, please book a 15-minute consultation so we can talk about that and what you can do to kind of sift through the junk mail that's going to be coming to your house. Okay. Oh my gosh, last story. I'm going to sing this commercial. I'm sure you've heard it. Celino and Barnes, injury attorneys, 800-888-8888. I hear that commercial all the time. They're like this famous personal injury firm. If you know that song, give me a star in the comments. If you've heard that jingle, give me a star in the comments. Celino and Barnes, injury attorney. All right, I'm going to go ahead because I'm about to run out on time on one of y'all. Okay, so Celino and Barnes is this famous personal injury firm, right? But they are splitting up. Barnes is suing Celino's wife and daughter because his wife and daughter have started their own law firm called Celino and Celino. And he's saying that it's just a shell company for the old business partner, Celino. He also said that they have a confusing phone number and they're trying to capitalize on the fact that the Celino and Barnes firm is dissolving. Now, the wife and the daughter, they're saying that this is meritless and they're just like, look, we're just trying to work. We're just trying to be lawyers. But it seems kind of weird that your business partner, you're dissolving your business and all of a sudden your wife and your daughter want to start a law firm, which is your same business with kind of the same name and a similar phone number. So I think that this is going to be a fun and interesting story to look at because this is a case between 2 lawyers. Like, I think it's funny. Okay, guys, this week was so long. Thank you so much for your participation. This was so fun. I didn't even feel the time going by. Thank you to the new followers. Thank you for your energy. Thank you for asking questions. Thank you for participating. If you want to reach out to me, DM me, tell your friends about the replay, share it with them. I'm going to take this and put it up on my YouTube channel. It's going to be housed there forever. So if you ever want to watch it again, if you want to set up a 15-minute free consultation with me, go to linktr.ee/nplconsultingfirm. And I will be here next week, same time, same place. If you have stories, send them to me. I want to talk to you. We got a few more minutes. I can stay on here. I can answer questions. If you have questions about your business, if you have questions about any of the stories I'm talking about, I'll stay on here until Instagram runs out because it's only a few more minutes. Any questions about contracts, about how to protect your logos, about how to, you know, register your company with the state, how to get an EIN number? I help you with all of that. Gumbo Grigri, I love your name. It's so cute. All right. Yeah, okay. I'm gonna give y'all like a couple more minutes. I don't want to sit here and like in silence. Oh shoot. I forgot to, I'm gonna need a yeah, you can set up the consultation link in the bio right there. And it'll link right with my calendar and you can we can chat, girl. I gotta go put on some chapstick. All this talking made my lips dry. Oh, awesome. Good. I'm happy for you. Awesome. That's it? Oh, whew. All right. They're giving me the countdown. Guys, I'm going to leave y'all here. Have a good night. Be blessed. DM me if you got any questions, comments. I love to hear from you. Bye.